Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Yesterday, the Edgecomb trial came to a conclusion. I want to talk about that in just a moment. So, whenever you sit down with an attorney to talk about a criminal defense, you really should listen to the attorney, especially if they're competent. If they are not competent, I don't know what you do, but you have to find somebody who has tried this kind of case before and hopefully had a good result, not a bad one. And unfortunately for Mr. Edgecomb, he either got bad legal advice, bad help, or he just didn't listen. One of the two, or one of the three, I guess. So, sorry, one of the things that I neglected to mention in my video when I was recording it earlier is the fact that although they had pleaded self-defense throughout the entire pretrial phase of this case, when Mr. Edgecomb testified, he testified that the gun went off by accident, which essentially negated the entire defense of self-defense. So either he didn't listen to his lawyer about the issue of self-defense, or it just spontaneously happened that he thought, hey, maybe if I say it's an accident, I get off with this thing. Either way, he made a rather serious error. He either didn't listen to his lawyer or he just went off extemporizing on what he thought would help him. Sometimes clients do that. It's never a good idea, and it's a shame that he did that. I think it really hurt his case. Now, back to the video. Let's talk a little bit about the cross-examination. Now, the Edgecomb cross-examination is online. It's here on YouTube on Law and Crime's video channel. You can click on it. It's about 53 minutes long. It is the most frustrating and irritating 53 minutes you will ever watch, because whenever he is asked a question he does not want to answer, which on cross-examination is pretty much every question, his response is, could you repeat that? Now, I understand that sometimes questions can be confusing, but when somebody says, what time is it? The answer is not, yes, or I was defending myself. The answer is, it's 2 o'clock. That's how you answer the question. You answer it directly. And if somebody asks you a yes or no question, did you take your bike down the stairs? That's a yes or no question. The answer is not, I was in a state of shock. I was defending myself. I didn't know which way to go. That's not the question. And of course, the prosecuting attorney here did a really good job of staying after Edgecomb and getting him finally to admit, yes, I took my bike down the stairs. Yes, I took the bike path. Yes, I went to my house. Yes, I left the bike. Yes, I walked away from my house. And then later on, he's talking about the fact that Edgecomb admitted that he threw the gun out the window somewhere in Indiana. I'll put aside for a moment the idiocy of throwing a gun out the window, where it could be found by a child who might hurt himself, where it could be found by another criminal so that you could get blamed for another crime. Any of those things are a complete possibility when you throw a gun out the window. It's a stupid thing to do, but that's what he did. So the question that the prosecutor had was, when did you decide to get rid of the gun? It wasn't after he shot the man. It was well into the second or third state. And that's what he was trying to get Edgecomb to admit. And it took 20 minutes to get there. When he got to the point where he talked about Edgecomb being stopped by the state trooper in Kentucky, it took him 15 minutes to get him to admit, yes, I lied to the state trooper. I didn't give him my real name, and I told him, if I had told him I was coming from Texas, that would be a lie. He says he didn't tell him he was coming from Texas, but of course the trooper said that's exactly what he told him. So it's a very frustrating thing when you are a defense attorney and you have prepped your witness for cross-examination and you have given them instructions about how to answer questions. Yes, no, I don't know are all good answers. I don't recall if you honestly don't recall. But you got to tell the truth. And here's the really awful thing if you're sitting on the defense side of the bar and your client starts saying, could you repeat that? Every time the prosecutor asks a question, where did you throw the gun? And you say, could you repeat that? It gives the prosecutor another opportunity to ask the same question, which after a little while stops becoming a question and starts becoming a statement in the minds of the jury. So all you're doing is reinforcing the bad answer that you are ultimately going to have to give. Another interesting side note that I neglected to put on the video, but I wanted to get in here because I think it's important, and that is that on cross-examination, Mr. Edgecomb said something to the effect that he didn't have any attorneys, when the prosecutor said, but you had 2 attorneys already. And he essentially denied that, and that opened the door to getting in the fact that he had other criminal actions that were pending. Normally, that kind of thing can't be admitted, and in this case, the actual nature of those bad acts was not brought into evidence. But the fact that he had these other criminal charges was brought into evidence because he made it relevant by essentially answering the questions in a way that was untruthful or at least misleading. And as a result, he gave the prosecution additional ammunition against him. It is one of the most frustrating things you can have as an attorney when you have a witness on the stand and they either don't understand the question or they think they understand the question and they want to be clever. Rather than taking a moment to think about the question and answer it as carefully and honestly as they can, they just go to a knee-jerk reaction of denying everything. And jurors tend to see through deception. They see through lies. It's one of the good things about a jury. They're really good at figuring out when somebody is not being candid with them. And I think the entirety of the Edgecomb cross-examination just pretty much demonstrated that he was incapable of being candid with the jury in this particular case. So again, back to the video. And the judge was very good about keeping this gentleman on track and making him answer the questions to the extent that he could. Now, in some respects, the prosecution didn't push too hard because they knew the jury could see what Edgecomb was doing here. And, you know, I got to give him credit. I thought this was probably one of the more effective prosecutors I've seen on any of these high-profile cases, high-profile criminal trials. I thought he did a marvelous job of getting to the point. And then he got up and did about a 20-minute closing argument where he went through the elements of the crime. And he called out the defense for saying that the defense had suggested in their questions and in their opening statement, I guess, that Mrs. Clearman did not love her husband. They kept referring to her as purportedly loved, meaning, well, it could be or maybe it couldn't be. And he nailed him on that. He said that was offensive, it was disingenuous. They had been married for 23 years, and in the back of the squad car, the video that the jury got to see when it was played, showed her absolutely devastated by this outcome. So doing those kinds of things, the defense attorneys probably crossed the line. When they got up to do the closing argument, they went on for more than an hour. Now, defense, they get a little bit of latitude on a closing argument. They don't have to stick to strict time limits usually because They don't want to the judge does not want to limit them in terms of the time because that might be a denial of due process. He went for over an hour. I think it was an hour and 20 minutes that he went with his closing argument. And the prosecutor got up and in 12 minutes completely disassembled that closing argument. It was a masterful job that the prosecution did in that case. And as a result, he was convicted. Now, he wasn't convicted of first-degree intentional murder. He was convicted of reckless homicide, which is a Class B felony. Goes up to 60 years in terms of punishment. Keep in mind, he's had other offenses, so he's not going to get a first-time offender break. And in addition, he used a deadly weapon in the process, and that's going to get a 5-year enhancement on top of whatever he gets for the killing. So this was a pretty fair trial, it looked to me like. The allegations that some people have made that the state got rid of video testimony that would have supported him was completely destroyed in the closing argument when the prosecutor pointed out that the bicycle that he had been riding had no paint on it. It had no damage. It wasn't damaged at all. There was no damage on the Clearman car. Thus, his allegation that the Clearmans had hit him with their car was specious. And I think, again, the prosecution did a masterful job there. He started a fist fight, and then he ended the fist fight with a gun. That was sort of the theme that the prosecution used. It was well done, and as a result, Edgecomb was convicted. So we'll see what the sentencing is in April, and hopefully I'll have a chance to do a video on that too. Thank you very much for watching. If you have any questions, please leave them in the comments down below. If you haven't already, please go over here and subscribe to our channel. Touch the notification bell so you can be notified anytime we release a video. Otherwise, thank you very much for watching. I appreciate your viewership. I appreciate you supporting the channel. And I'll catch you on here next time. Bye.